everybody. Welcome back. Me again. So, brand new topic today. We are all done with one of the major topics, perhaps the largest single topic for this semester, and that is the law of fiduciary duty and the associated procedural rules. That said, let's drop a little footnote there. What we've really covered is the traditional fiduciary duties. Remember, something I said was that while up until probably the mid-20th century, there really had only been two major fiduciary duties in the law of corporations and in the law of fiduciary duty more generally. And those were the duty of care and the duty of loyalty. That's what we've finished. It turns out that in corporations, the courts have actually devised a couple of other important rules that we are going to talk about this semester. And specifically, there are two. In fact, one of them arises in this topic that we're starting today within the context of the law of mergers and acquisitions, the law of changes in corporate control. It turns out that the courts of Delaware actually invented a special fiduciary duty. They describe it as simply an application of the business judgment rule, but really it is a significantly different fiduciary duty that sometimes arises in mergers and acquisitions, and specifically in hostile takeovers. Okay, hostile or unfriendly transactions trigger a special fiduciary obligation in Delaware. We'll talk about that a whole lot later on. If you want to make a note of it, that duty will be referred to by us and by everyone else as the Unocal/Revlon duty. The Unocal, U-N-O-C-A-L, Revlon duty. Okay. Anyway, there's one other fiduciary duty that we'll talk about this semester, and that is a special rule that applies sometimes in cases involving close corporations, closely held companies, as opposed to public companies. And that special rule is known as the Donahue duty, sometimes as we will refer to it, the Donahue-Wilkes duty. And we'll talk about that in another segment of the semester later on. All right, so overall, the four fiduciary duties we'll talk about are the traditional duties of care and loyalty, the Unocal-Revlon rule, which applies in hostile takeovers, and the Donahue-Wilkes rule for close corporations. All right, but all that's done, and we are starting something new. So what we're going to talk about is often referred to as mergers and acquisitions or changes in corporate control. So when companies buy control, or when a person buys control in a corporation, turns out that triggers a whole bunch of special legal mechanics, a whole bunch of special rules contained in statutory corporate law and sometimes in the common law decisions of the courts, most of which exist to protect shareholders. So the interests of shareholders are sort of especially acute in cases of mergers and acquisitions. First of all, one thing we've made reference to throughout the whole semester is that built into statutory corporation law is the idea that while shareholders nominally have a role in governance, and they are literally the owners of the corporation, their role in governance really is very limited, and in the ordinary course of business, their only real role is to vote at shareholder meetings, and the only votes they usually get to cast are votes to elect the board of directors. So their governance role is really very attenuated in the ongoing life, everyday life of a corporation. But the law, nevertheless, carves out certain special cases in which shareholders are entitled to special additional opportunities to cast their shares. And those are events that are really significant in the life of the corporation. We've mentioned these several times. So amendments to the Articles of Incorporation require shareholder vote. Dissolution of the corporation requires shareholder vote. As you can see, these are significant events in the life of the corporation. Well, changes in control also are significant events in the life of the corporation, and at least sometimes shareholders are entitled to cast their shares to approve or disapprove some change in control transactions. So that's a lot of what we're going to talk about. When do shareholders get to vote, and what other rights and duties are triggered? Another set of the rules we're going to talk about surrounding change in controls transactions relate to the effects of these transactions on the rights and liabilities of corporations. It turns out that you can set up a merger and or acquisition deal in different ways. And the different ways that you can set it up have different legal consequences. Okay, so for one thing, depending on how you set it up, The surviving firm, the firm that's left over after the transaction goes through, may or may not retain the liabilities of the original companies that they had before the transaction took place. Likewise, depending on how you set up the deal, there can be different tax consequences. Okay, so all that stuff sets up a problem, an interesting problem that will amuse you if you're cynical like I am. And that is, when there are different ways to do things as a matter of form that have different consequences, lawyers can be counted on to figure out how to use the formal differences to get different kinds of consequences, to get different kinds of benefits, minimize different kinds of losses on behalf of their clients. And sometimes it can seem a little shifty, it can seem a little dishonest. And to some extent, the courts and legislatures have tried to regulate this a little bit, have tried to control it in the ways that they've designed corporation statutes. And that's true in particular of the Model Business Corporation Act, as we shall see. We've seen this kind of thing before, by the way. Remember, it was true, this was a major theme in the story of the creation of the limited liability company. It used to be that you couldn't combine, except in limited circumstances, you could not combine in one business the two desirable goals of having limited liability for all the owners and pass-through tax treatment. There was a lot of lawyerly funny business, though. Lawyers figured out various ways to produce that practical result for their clients. And in fact, they figured out how to produce it very precisely, even before the limited liability company came into being. So eventually legislatures and the Internal Revenue Service just kind of cried uncle and said, fine, you can have a limited liability company and we'll give it pass-through taxation. Same thing was true with the development of, in a way, was true of the development of Delaware as the leading corporation state. Corporations and their lawyers realized that since corporation law was imposed at the state level, well, you could basically have whatever you want just by incorporating in whichever state gave you the best deal. Okay, so mergers and acquisitions involves yet another one of the familiar stories in the history of business organizations law, in which lawyers have come up with ways to serve their clients' interests by using the form of the law to moderate the consequences of transactions very precisely. Okay, anyway, so that leaves a fair bit of technical legal stuff for us to figure out today. And how about we dive into that? So the first thing I want to do is, and this follows material that appears in the beginning of the reading assignment. So starting on page 701 of the second edition, there is a brief discussion that doesn't get too much into the legal details of the different kinds of transactions. I'm taking these slightly out of order, in a slightly different order than they appear in the book, but I'm doing that because of the way that we're going to talk about the statutory materials that we talk about today. Now, one thing I want to say before we start in is that this is material in which the details of the statutory code provisions that I provided you, that I assigned you to read, are actually pretty significant. So for the rest of this lecture, I think it's probably a really good idea to have the assigned statutes in front of you. I'll put them up on little cards in this video, but you really ought to be working pretty hard with the statutory materials in front of you at this point in the semester, and you can't really understand this material without digging into it. Okay, so let's talk about some transactions. Okay, so we begin with, in some ways, the most basic transaction, the most familiar to us, the paradigm corporate control transaction, and that is the basic merger. So in a merger, you have two corporations existing separately. There is a transaction in which one of the firms, at least, will merge into the other and cease its existence. The final result can depend a little bit. Different things can happen depending on what kind of consideration is given to the target firm shares. But in this case, we've assumed that the target firm shareholders all get shares in the acquiring firm as their consideration. So following that transaction, the shareholders who had been shareholders in separate corporations are now all shareholders in the surviving corporation, which is Corporation A here, and we refer to that as the acquiring firm. Now there's another form that mergers can take, and that is the so-called consolidation. That's a transaction in which neither of the original firms survives as a continuing entity, and the shareholders of both of the original firms are merged into shareholders in the surviving firm. The legal rules are largely similar, although, as we'll see, there are some distinctions in the way that these things work. Okay, so next, there's a different sort of transaction, at least in some jurisdictions, and in particular in Model Act jurisdictions, in which you can structure a change of control transaction that's largely similar but has a somewhat different outcome, and that's the so-called share exchange. So in this case, instead of the two firms combining into one, either combining them both into the acquiring corporation, which survives under its same identity, or both of them combining into a new surviving firm, which we call a consolidation. In this case, the acquiring firm merely acquires all the shares of the target firm, and then the target firm continues as a subsidiary. In this particular drawing, as we've displayed it in this, this chart, we're presuming that the target firm shareholders are given as consideration for their shares in the acquiring company. It doesn't have to be that way. They could get other kinds of consideration, and obviously they could get cash. If that were the case, the end result would simply be that Corporation A still has its same shareholders. The Corporation B shareholders are no longer part of the picture, and A simply owns B as a subsidiary. All right, now importantly, you can accomplish the same practical effect as a change in control without doing either a merger or a share exchange, and without getting rid of the original company at all. So both firms can survive, even though the same practical effect of a consolidation of control happened. And that is by having one of the corporations simply sell all of its assets to the other one. So in that case, the selling company will continue as a corporate entity. You might wonder why, because it seems like, well, if it doesn't have any operating business, what is it even? Like, did the shareholders just own shares in an empty shell full of nothing? Before you jump to that conclusion, though, think for a second about the one asset that selling company does in fact have. Your instinct may be to say that it doesn't have any assets at all, but it turns out it has one great big asset, and that's typically going to be a big fat pile of money sitting in a bank account somewhere. So the merger proceed, the sale proceeds will be that company's remaining assets. Typically, following that kind of transaction, the target company will simply distribute the money to its shareholders and then dissolve. There are reasons for doing it this way. There are reasons for choosing any one of these transactions. We're going to talk about all of that stuff. Before we do that, though, let's talk about just a couple of other ways that a change in control transaction can be structured. Okay, so maybe the most important, most major alternative to those other means for structuring change in control transactions, those other means being heavily statutorily regulated, is the so-called tender offer, also frequently known as a hostile or unfriendly takeover. These transactions are not quite as clearly regulated or closely regulated by the corporation statute, because a tender offer really is just a purchase of shares on the open market by one person or one company from shareholders of a target corporation. So if you want to buy a company, you don't really have to do a merger, you don't have to do a share exchange or any of that nonsense. You can simply go directly to the shareholders of that company and ask them to sell you their shares. If your tender offer is successful, then you buy up a controlling share, perhaps all of the shares, but not necessarily. You just get control through acquiring a majority of the shares of the target firm, and then it is effectively your subsidiary. Okay, so it turns out these things are actually quite a lot more complicated than I've made it sound. They're subject to all kinds of regulatory oversight, including under the federal securities laws, and there is some statutory corporate law. There's a provision of the Model Act that we're not going to look at that does relate to tender offers, but there isn't really very much control over tender offers in state corporation statutes. All right, and finally, legally the simplest way that control can change hands is if a firm has a controlling shareholder and that person or entity simply wants to sell to another individual buyer. That really isn't a transaction regulated by statutory rules at all. It is subject to some fiduciary case law, but basically in terms of statutory law, it's very simple. It's just a sale of one person's property to another. Okay, so we're going to have to dig into the statutory mechanics now of how these transactions work. And in particular, we're going to talk about the Model Act rules governing mergers, share exchanges, and sales of assets. As I tried to imply, and as you've seen, because I know that you've done the statutory reading assignment ahead of time, these rules get pretty hairy. These statutory provisions are a little bit complicated. And they've gotten that way because, at least in the Model Act, the drafters of the statute have attempted to keep lawyers from gaming the system in certain ways. And in particular, they've attempted to keep them from disadvantaging shareholders in certain key respects. So let's talk about what the differences could be between transactions, depending on how they're structured as a legal matter. So a transaction, even if it might not be any different in economic substance, could have different consequences depending on how it is set up as a legal matter. The drafters of the Model Act have attempted to avoid that as much as possible by making the same rules apply to all the transactions, but they didn't do that completely. So we're going to dig out exactly why. Okay, so let's talk about what the different consequences might be. The major effects of structuring a deal in the different ways that could differ as between the different ways of structuring them are that a transaction will have an effect on the liabilities of the two original firms. Sometimes the liabilities transfer to the surviving firm, sometimes they don't. They can also have an effect on rights of the shareholders, which basically means procedural rights. So in most change in control transactions, the shareholders of at least one of the firms, the firm that we call the target firm, will have a right to vote to approve the transaction. And generally speaking, also have a special right that we call the appraisal right, which is a protection from being forced to accept consideration from your shares that isn't adequate. If you get the appraisal remedy, basically it means that you get to ask a court to revalue your shares and pay you their fair value if the court determines that you didn't get the fair value in the transaction. All right, and then the final consequence that can differ between these things is tax treatment. So here it turns out there's kind of a significant rule. Mergers, true mergers, where two firms execute a plan of merger, the shareholders approve it, and the two firms merge into one. As far as tax law is concerned, that's not a tax event. So in other words, nobody involved in that transaction, neither the merging entity nor the shareholders of either firm, have to pay any taxes as a result of the transaction. All right, that's different in the other ways of structuring this. So a purchase of shares in a share exchange or in a tender offer or a purchase of assets is a tax event, meaning that the person who's selling, so the shareholders who are selling their shares or the corporation that's selling its property, they may realize tax gains that trigger income tax liability. So one major reason for structuring a deal as a merger is to avoid tax liability for the shareholders of at least one of the firms. So, okay, so traditionally, there was gamesmanship. Lawyers in various jurisdictions did in fact play games to try to mix and match these various rights and duties by structuring deals in different ways. And in particular, lawyers figured out, and we're going to see this in the case of Ferris versus Glen Alden and also Heraton versus Arco Electronics, we're going to see that lawyers figured out you could set up a deal so that on paper it looked like a sale of assets, meaning a sale of the actual operating assets, the factories and the trucks and the inventory and so on. A sale of assets, even though in economic substance it was definitely a merger. The selling firm would cease to exist and its shareholders would become shareholders in the acquiring firm. That's a merger, but you could set it up to look like a purchase of assets. Well, traditionally, a sale of the corporation's assets didn't trigger shareholder voting rights and didn't trigger appraisal rights. Okay, so There had been gamesmanship. Corporate lawyers figured out they could structure these deals in different ways, and they would do that to sort of mix and match the desirable benefits. Generally speaking, a very desirable benefit of the merger would be its tax treatment. An undesirable consequence of the merger, though, was if you set it up as a merger, shareholders in at least one of the firms get voting rights and appraisal rights. And moreover, a merger is also the only one of these transactions in which the target firm's liabilities transfer to the acquiring firm. All right, so if you want to buy a firm that, for whatever reason, is desirable to you, even though it has a whole bunch of liability risks, merger was kind of disadvantageous, and you wouldn't really set that up as a merger unless you really needed to get a big tax benefit. All right, so that's the kind of give and take, the pros and cons of these deals, and that explains how why lawyers sort of set them up in different ways. All right, well, anyway, as I said, the Model Act goes some ways to taking out the gamesmanship because it treats all the transactions in largely the same way. That is, it treats a merger, a share exchange, and a sale of assets all largely in the same way, at least with respect to the rights that are given to shareholders. Okay, so let me say that again. A merger, a share exchange, and a sale of assets all trigger the same procedural rights for shareholders, namely the shareholders of at least the target firm are entitled to vote to approve or disapprove the deal, and they are entitled to appraisal rights at least sometimes. So, okay, with all that in mind, now, oh, by the way, one thing I didn't say, though, is one significant consequence of a change in control transaction does, in fact, differ in Model Act jurisdictions among these various forms, and that is whether or not liabilities will transfer. So again, the only one of these deals forms in which the liabilities of the target corporation transfer to the surviving firm is the merger. And that's true for a very simple reason. If a deal is set up as a share exchange, well, the acquiring corporation is not it's not merging, it's not becoming one with the target. It's rather buying the target as a subsidiary, and the firm will then exist as a parent corporation, and just like any other shareholder, it enjoys limited liability. Likewise, with purchase of assets, the acquiring firm isn't buying the target firm. The target firm continues to exist as an independent entity, and it keeps its own liabilities. Okay, so there are some qualifications to all these things, and we have to work through some intricacies. We also have to work through some case law to see how it really works. But with all that in mind, let's turn to that work now and figure out the statutory details. So I want us to begin with the little barrage of rules in the Model Act that govern mergers and share exchanges. So let's turn to that now. Okay, so most basically, sections 11.02a and 11.03a just tell us what merger and share exchange are. So 11.02a tells us that following a merger, only one of the firms survives. Section 11.03 tells us what happens following a share exchange. Okay, turning to more important matters, Section 11.04 tells us how you actually make a merger or share exchange happen. We're told that, first of all, the plan of merger or share exchange shall be adopted by the board of directors. Now, the plan of merger or share exchange is an agreement that is negotiated between the managements of the acquiring firm and the target firm, and both boards have to approve it. Under subsection B, we're then told that, subject to certain exceptions, which we're going to talk about in detail, the plan of merger or share exchange has to be approved by the shareholders. We're told the board of each corporation has to recommend that the shareholders approve. Provision is made for the board not to make a recommendation if, in fact, there are conflicts of interest on the board. They then simply submit it to the shareholders without recommendation. Okay, so as I implied, there are certain special rules that apply to shareholder voting. And first of all, under sections 11.04e and f, we're told initially that unless certain other provisions apply, approval by the shareholders means approval by a majority of those present at a shareholder meeting at which there is a quorum, and a quorum exists of a majority of votes entitled to be cast on the plan. However, 11.04F tells us that there are certain cases in which particular groups of shareholders are entitled to vote as a class, and that means that that class has to also approve the deal. Independently of the larger majority, that class has to approve the deal by a majority of a quorum of that class. And those special circumstances basically are cases in which that class of shares will be particularly affected. So if one class of shares is going to be phased out completely, or its rights or obligations are going to be changed in some way by amendments to the Articles of Incorporation following the merger, or if that particular class, in the case of a share exchange, that particular class is a target of the share exchange, then it's entitled to vote as a class. Okay, but that then brings us to several specific circumstances in which there are exceptions to the right of shareholders to vote. Okay, let me just be clear. In every merger or share exchange, with very limited exceptions, at least one corporation's shareholders get to vote. But there are some circumstances where the shareholders of one of the corporations does not get to vote, and so we'll talk about those. So first of all, under section 11.04H, we're told that a corporation's shareholders don't get to vote on a plan of merger if their corporation will survive the merger. And there are some other little qualifications there, but basically that's the idea. In a simple merger in which one of the firms is simply merged into the other, and that acquiring firm continues as a surviving entity without meaningful change, then its shareholders don't get to vote. Likewise, 11.04 L tells us that in share exchanges, the shareholders of the acquiring firm don't get to vote. That then brings us to a different exception, which is contained in section 11.05. This is for parent-subsidiary mergers. This is also often known as the short form merger. In model-like jurisdictions, 11.05A says that a parent corporation that owns at least 90% of all classes of stock with voting power can merge the subsidiary into itself, and in this case, without approval even of the board of directors of the subsidiary and without approval of the minority shareholders in the subsidiary. And that's that. Interesting little fact here, and kind of a review point, is that the parent corporation in those cases often will, in fact, hold a vote for the minority shareholders of the subsidiary. And that's for the simple reason that that vote, even though it's not legally required, can have the effect of a ratification. Remember when we talked about the Wheelabrator case, we saw that if there's a ratification of a controlling shareholder transaction, which involves a conflict of interest, ratification by the minority shareholders following full disclosure and assuming that the minority are all disinterested has the effect of shifting the burden of proof from a plaintiff shareholder in a derivative suit. Has the effect of shifting the burden from that controlling shareholder defendant to the plaintiff. Still a duty of loyalty case, but it shifts the burden to the plaintiff to prove unfairness. All right, section 11.07 tells us what the effects of a merger and share exchange are. 11.07A tells us that the plan of merger, in the case of a merger, has to specify some entity as the surviving entity. Now that can be one of the original merging firms, in which case it's more like a merger where one of the firms is an acquiring firm and it survives. But this could also apply to a consolidation where the plan of merger specifies that a new corporation will survive and the two original firms merge into it. 11.07A2 then says the separate existence of non-surviving entities cease. Property owned by and each contract possessed by each domestic or foreign corporation becomes an obligation or property of the surviving firm. All debts, obligations, and other liabilities become those of the survivor. Subparagraph 9 says, except as provided by law or the terms of the deal, the rights, privileges, franchises, and immunities of each entity become those of the survivor. And finally, if the survivor exists before the merger, its property, contract rights, and etc. remain all its possessions after the deal. All right, 11.07B then governs the effects of share exchange. And this is much simpler because it provides basically that the consequence is that the acquired firm continues then as a separately existing entity with all the obligations and rights that it had before, and none of them become the obligations or rights of the acquiring firm. All right, so let's review. In the case of a simple merger in which one firm will merge into the other, in this case, the transaction is drawn as if B is the surviving firm. So in this case, both companies' boards of directors would negotiate a plan of merger. They would both approve it. Only the board of A has to recommend the deal to its shareholders, and only the shareholders of A will get to vote, because under 11.04 H, B is the surviving firm, and presumably its shareholders won't have significant changes in their relationships to the company that would trigger voting rights. Following the deal, B takes on all the liabilities and rights owned by A before the deal, and A ceases to exist. Essentially, all the same rules would apply if it's a genuine consolidation in which both original firms will cease to exist, except now the shareholders of both firms are entitled to vote. So a share exchange is a little bit different. In this case, Corporation A is acquiring the shares held by the shareholders of Corporation B. Only the shareholders of Corporation B are entitled to vote. That's a consequence of Section 11.04 L. Surviving firm doesn't get to vote in a share exchange. And following the deal, B will continue as a wholly owned subsidiary of A, and it will retain its rights and liabilities. Those don't become the rights and liabilities of A. A is just like any other shareholder and enjoys limited liability. Okay, now let's talk about a couple of things that may not have been exactly obvious from this discussion. First of all, remember, in the case of both mergers and share exchanges, the shareholders of at least the target firm get to vote. But remember, it only takes a majority of a quorum of the shareholders to approve either of these deals. And typically, the plan of merger will call for at least a majority of the shares of the target firm to be acquired, and oftentimes all of them. So it stands to reason that sometimes people are going to vote against these deals, but the deal goes through. When that happens, if you're a dissenting shareholder, it sucks to be you, because you will be forced to accept the consideration that was negotiated and relinquish your shares for it. Okay, so let's just be clear about that. A merger or share exchange cashes out all those shareholders that the plan applied to, whether they want it or not, so long as a majority of them approve it. And remember, it only has to be a majority of a quorum. So strictly speaking, about a quarter, just a little bit over a quarter in principle, could approve a deal that cashes out 100% of the shareholders of the target firm. Okay, so one other thing to understand is that there's a different kind of transaction that we haven't talked about yet, and that's the purchase of assets. So a deal in which the shares of the target firm aren't acquired or affected at all, and the target firm continues in existence as a freestanding entity that is not owned, or entity doesn't have any other relationship to the acquiring firm at all. But because the transaction has aspects of a change in control transaction, the Model Act at least provides some rules to protect shareholders of the target company. So let's take a look at the statutory rules. These are from Chapter 12 in the Model Act, and here we go. Okay, so sales of assets work like this. Now, ordinarily, a sale of assets doesn't trigger any special statutory rules. If you just want to sell a factory, or you want to sell some inventory or whatever, that doesn't trigger any statutory corporation law rules. It does trigger those rules basically when it's a sale of all assets, when it's a sale that would leave the firm without continuing operating business. So this rule is provided in two sections of Chapter 12 of the Model Act. So Section 12.01 starts off by saying that no approval is required in certain circumstances. No approval of the shareholders is required unless the articles otherwise provide to sell, lease, exchange, otherwise dispose of any or of all the corporation's assets in the usual or regular course of business, to mortgage, pledge, etc., to transfer any or all of the corporation's assets to domestic or foreign firms, etc., and to distribute assets pro rata to the holders of one or more classes of the corporation shares. However, Section 12.02 then says that sometimes you do in fact have to get shareholder approval, and that is as follows. All right, well then 12.02a says that shareholder approval is in fact required wherever a sale, lease, exchange, or other disposition of assets other than the disposition described in section 12.01. If the disposition would leave the corporation without a significant continuing business activity. Now, this can pose a bit of a fact question because sometimes a company will still have some assets and the company will try to say, well, this wasn't a disposition within the meaning of section 12.02 because, look, we still have a factory and stuff. So there's a question for the court, but subsection A says you are conclusively presumed to have a continuing business entity only if you keep 25% of the total assets that you had before. If you have less than 25%, then there's a fact question for the court. 12.02b and E set out some rules for how the shareholder approval happens. First of all, 12.02b says there has to be a plan for the asset distribution approved by the board, and then that plan has to be submitted to the shareholders who have to approve it by a vote of a majority of a quorum. Okay, well, since 12.02 says that whenever a firm would be left without a significant continuing business, shareholder approval is required except as provided in 12.01. That requires us to look back again at 12.01, which says there are certain circumstances that don't require shareholder vote, even though the firm wouldn't have a continuing business after that point. The most important of these is where sale or exchange of all the firm's assets are in the ordinary course of business. You can imagine that in a few different kind of scenarios. Most importantly, in the case of firms that are in the business of buying and selling assets, speculating in assets. So for example, firms that maintain portfolios of real estate for investment purposes, they really might sell everything on an ongoing basis, and they don't have to go to their shareholders for approval. Okay, so just to review, let's take a look at the chart, the diagram of a sale of assets again. So in this case, B is selling all of its assets to A. As we've drawn the picture, A is giving shares as consideration for these assets. In that particular case, A continues as a surviving company which owns all the assets of B. B, in that particular case, continues as a surviving firm that is also a shareholder of A. If cash had been given instead of consideration, then B wouldn't have any relationship to A, and its shareholders wouldn't have any relationship to A. Bear in mind, the major statutory consequence for a purchase of assets structured like this is that unless one of the exceptions in section 12.01 applies, if it's a sale of assets leaving B without a continuing business, then its board and shareholders have to approve the deal. Okay, so something we've been leading to all along that is implicit in all this discussion is that there are some differences in the legal consequences that follow for these transactions depending on the form in which they're put, and in particular, a change in control that is structured as a mere sale of assets has different legal consequences. Even in a Model Act jurisdiction, that transaction, while it does give shareholder approval rights to the target firm, it doesn't cause liabilities of the selling firm to transfer to the acquiring firm. It turns out that in non-Model Act jurisdictions, in many of them, and traditionally this was the case in most jurisdictions, shareholders in the position of the target firm, shareholders, the selling firm, they didn't get voting rights or appraisal rights. So that was a reason that oftentimes a deal would be structured as a sale of assets, even though in practical circumstances it was a merger. Okay, so traditionally some courts recognized this problem as an unfairness to shareholders. They also recognized it as an unfairness to third parties, since tort claimants and contract claimants of the selling firm might be pretty unhappy to learn that the selling firm had sold off all of its assets in a transaction that didn't transfer their rights along with the assets, because very often the selling firm would then distribute the proceeds of the sale to its shareholders and dissolve, and those claimants would be left with only claims against a defunct, dissolved entity. Okay, so courts using their common law powers of equity in some circumstances came up with a solution for this, and that solution they described as the de facto merger doctrine. So discussion of that begins on page 707 with a case called Ferris versus Glen Alden. All right, so I think this case comes off as pretty confusing, hard to figure out at first, mainly because of the transaction. The transaction looks complicated. Um, it turns out it's not really so complicated once you work through it, and we'll see that there's a fairly simple explanation of what happened and for why the parties set it up in this cockamamie fashion. But let's take a look at a drawing. Okay, so we got this company called Glen Alden Corporation. And it's kind of important to think a little bit about what its business was. Glen Alden was relatively small. It owned a coal mining operation in Pennsylvania and a few other businesses. The firm was also struggling financially. Like other firms, Glen Alden had shareholders and a board of directors. So Glen Alden, in part to deal with its financial problems presumably, decided that it wanted to have a relationship with a firm called List Incorporated. Now, List was quite a different business. List was a holding company, and it was engaged in a big business, a nationwide business of diversified operating subsidiaries. List also appears to have been quite successful financially, had a lot of cash on hand, and was borrowing money, but borrowing it to fund capital expansion. Sure enough, List also had a board and shareholders. Well, to do the deal they had in mind, Glen Alden and List hatched a plan of reorganization. And this thing turns out to be pretty hairy and really kind of nifty once you figure it out. Okay, now before we get into the details of how this complex plan worked out, let's look at it in the big picture and think about what it actually accomplished. Like, what in substance was this really? What this was, even though on paper the transaction is structured as if Glen Alden is buying List, that is really, really not what happened here. In all practical, for all practical purposes, List acquired Glen Alden. Okay, let me say that again. List, a big, nationwide, diversified operating company, a big, successful financial company, acquired a tiny little failing coal mine in Pennsylvania. Nevertheless, the parties set it up as if, on paper, it were a purchase by Glen Alden of all the assets of List. Okay, so let's talk about how this thing worked and why it was really a purchase by List of Glen Alden rather than vice versa. Okay, so first of all, the plan of reorganization required some voting procedures. First, it was negotiated by the boards of directors of the two companies, and they voted to approve it. Then the shareholders of both companies were entitled to vote on it as well. All right, so far so good, but that's where the weird stuff starts kicking in. Once this plan is approved, there is a transfer of assets in exchange for securities. So all the property of List Incorporated, its factories, its businesses, its trucks, its bank accounts, its inventories, blah, 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 was transferred to Glen Alden in exchange for a big pile of securities. Now, something to keep in mind is this is a very large number of shares issued by Glen Alden in comparison to its existing outstanding body of voting shares. Namely, Glen Alden had to authorize new shares, and the number that it authorized tripled the number of its outstanding shares. Now let's stop and just think about what that really means. Glen Alden is already a pipsqueak little suffering firm, probably not worth very much, purportedly acquiring a super big firm. So the property that it acquired, namely all the assets of List Incorporated, surely outweighed massively the value of Glen Alden before the transaction. But not only that, Glen Alden tripled the number of shares. That means the existing original number of shares is now we're dividing the same pile of sort of inadequate, tiny little value into something, a number of shares, a number of fractional interests 3 times as large as before. So in other words, the 3 million shares that Glen Alden issued to List were not worth very much. Okay, they're worth bupkis. They're barely worth the paper they're printed on by comparison to the assets that List got. So that's indication number one, that this transaction in substance was not what it really, not really what it appeared to be on paper. Next, Glen Alden assumed all of List's liabilities. That's another reason to think that this thing really is kind of more like a merger. than like a sale of assets, because ordinarily a sale of assets doesn't transfer liabilities in that way. Next, List, which, remember, List is now effectively by far the largest shareholder in the Glen Alden Corporation, because the consideration it got for selling its assets was an issuance of Glen Alden shares. But List immediately distributes all of those shares to its own shareholders. This is what we sometimes call an in-kind dividend, because it's just a distribution to the shareholders of property owned by the corporation, not in the form of cash. Okay, but the practical consequence is that the List shareholders suddenly become shareholders in both companies, and they are by far the larger group of Glen Alden's shareholders. And the result, therefore, looks something like this. Next, the boards of the two companies are combined into one sort of super board that will become the new board of directors of the List Alden Corporation, which, by the way, as a part of this deal, changed its name. Okay, so let's think just for a second about what the List company is at this point. It still exists as an independent entity, and it's still owned by its shareholders, but it's really a hollow shell. It doesn't have any assets anymore. It distributed all of its assets as an in-kind dividend to its shareholders. The only assets that the merging parties left it with were a small amount of cash to pay off its remaining expenses. So the logical next step is that the shareholders of List Incorporated, on the recommendation of their board, voted to dissolve List. So this empty shell of a corporation would no longer exist. And that leaves us with the final result, which is an entity called List Alden Incorporated, with a board combined of the two prior boards and a shareholder body composed of the shareholders, all the shareholders of the two original companies. Okay, so this is what we might call a consolidation. It's a kind of merger that we might call a consolidation. The two original entities have ceased to exist. They both merged into a surviving entity with quite a different governing structure, quite a different capital structure, very different business, and so on and so on. But let's keep in mind, on the surface, on paper, this was structured as a purchase of assets. For all practical purposes, on paper, this looked like a deal in which the tiny little Glen Alden was simply buying the great big List in exchange for some of its shares. So the question that remains, though, is who cares? Like, what difference does it make that they set this up in one way and not another? And the answer is, well, one of those shareholders cared a lot. Some of the shareholders cared quite a lot. So under Pennsylvania law at the time, this is a Pennsylvania corporation governed by the Pennsylvania Corporation Statute, shareholders were entitled to vote on change in control transactions, specifically on mergers. This was set up as an asset sale, though, and you might say, well, wait, these shareholders were all given the right to vote, and that is true. Thing is, Pennsylvania corporation law, just like the law of other jurisdictions, also gave shareholders a right to the so-called appraisal remedy. Appraisal is a remedy under which, if you're forced to relinquish your shares in a change in control transaction, you can ask a court to revalue your shares and determine whether the consideration you were given was adequate. And if it wasn't, the court can order you can order the merging parties to give you the difference and make you whole. And that right was not available under Pennsylvania law to the shareholders in a target firm that sells sells or purchases its assets. So in this case, Glen Alden was set up as the purchaser of List's assets, and it surely was not given appraisal rights. And indeed, the lawyer when this case was litigated, the lawyer for one of the defendants just admitted, look, we set this up as a purchase rather than a merger, which is what it really was. Because if we had to pay appraisal rights to the Glen Alden shareholders, we couldn't have afforded it. There wouldn't be money on hand to pay for it. If you want to see that for yourself, it's on page 709 in note 4. Okay, so the question for the court was, are we going to let these guys get away with this? Are we going to let them effectively take away a statutory right, meant by the legislature for corporate shareholders to protect them in change of control transactions. And this court says, no, as a matter of equity, we're going to apply a doctrine that we'll call the de facto merger doctrine. So the rule says that when a deal is in substance a merger, and by structuring it as something else on paper, shareholders of either firm would be deprived of rights that they're entitled to under the statute. The courts can order the deal to be treated like a merger. Anyway, so the court gives us a fair bit of discussion on this, and says in the most general sense that a deal is a de facto merger when the shareholders' relationship to the business becomes something significantly different than what they originally invested in. Okay? I'll say it again. When the shareholders' relationship to the business becomes something significantly different than what they originally invested in, a court can treat the deal as a de facto merger and give that shareholder the benefit of some statutory rights. The examples the court gives of how the company was changed such that the original Glen Alden shareholders no longer had a relationship with the company of the kind they first invested in. The examples the court gives are that the new company, instead of just being a small operating business running some coal mines and other stuff, the new company is a holding company. Moreover, it's a holding company in a wide range of diversified businesses. It is a heavily leveraged company, meaning it's probably more risky. Remember, leverage means that a company has borrowed lots of money. So it turns out that List had borrowed lots of money to do its business. There's nothing wrong with that, and List seemed to be doing quite well with debt capital as its financing. But it also imposes some risk, and some shareholders don't like it. So shareholders in Glen Alden were forced to accept ownership of a company that was quite different and probably more risky than the one that they originally took, and they weren't given appraisal rights if they didn't like it. Also, the relationship between the shareholders and the management changed quite a lot, and the court seems to think that's pretty important. The management relationship mainly changed because, two things. The board of directors was more than doubled in size, and it came to be dominated by the directors of the original List company because there just happened to be more of them. The governance relationship also changed, though, because those Glen Alden shareholders had each one of them had proportionally much larger share ownerships of the company, just because the total number of outstanding shares and the total number of shareholders went up very significantly. Okay, so these are all facts that are relevant. It's obviously a facts and circumstances kind of inquiry. What's really important for you to understand is how to look at a transaction like this and see if it really is what it purports to be. And telltale signs can be found like the weirdness of a small company seeming to buy a large company, issuing stock that couldn't be worth what as much as the assets that are being bought, that sort of thing. Okay, so that's Ferris versus Glen Alden. Okay, next we have a short excerpt from a Delaware Supreme Court opinion called Haraton versus Arco Electronics. This is only in our book for one reason, one limited reason, which is to see that Delaware does not, in fact, follow the de facto merger doctrine. Otherwise, the facts and details are really very similar to Ferris versus Glen Alden. So Delaware doesn't follow this doctrine, even though under the Delaware statute, unlike the Model Act, it is in fact possible to pull the funny business that the parties were trying to do in Ferris versus Glen Alden. That is, you can set up a deal so that on paper it looks like a purchase of assets, and under Delaware law, that does not trigger voting or appraisal rights for the shareholders of the selling firm, of the target firm. And yet you can make it look like a purchase of assets, even though in substance it really is a merger. So let's just think very briefly about the transaction here. You have two corporations, Loral and Arco. Now this transaction isn't quite as cockamamie as in Ferris versus Glen Alden, because it's set up as if Arco really is selling its assets to Loral in exchange for Loral shares. Arco then distributes the Loral shares to its shareholders as an in-kind dividend, and Arco dissolves. So it has exactly the same practical effect as a merger. It's like Loral purchased the shares of the ARCO shareholders by offering them its own shares as consideration, and then ARCO dissolved. But since it was structured on paper as a purchase of assets, the court said no, Delaware law doesn't give ARCO's shareholders the rights to vote or appraisal in this case, so that's it. And the court said, look, it's clearly possible under the statute that this can happen, and we should presume that the legislature foresaw it, and therefore it's the legislature's intent that a transaction with these effects can occur. So this is actually, I think, the first of what will be several examples in which we'll see that the Delaware Supreme Court is just not that willing to cut people a break by using its equitable powers to avoid results that seem to be contemplated in the clear language of the statute. Okay, now, following the Haraton case on page 714 in the second edition, we have some think about this questions, kind of long, so let's read them. Biff was recently driving in his Roadstar 2000 station wagon when all four wheels fell off, the brakes failed, and the hood popped open, obstructing his view. He skidded into a ditch and suffered serious injuries. He would now like to bring a tort action for products liability against the car's maker to recover for his injuries. 2 years before Biff suffered his accident, Road Motors Incorporated, the maker of his car, entered into a transaction with another company called Megabeast Motors Incorporated. Megabeast, a publicly traded Delaware corporation, issued 50,000 of its own shares as consideration for purchase of the bulk of Road Motors' assets, its manufacturing facilities, its inventory, its patent rights, and so on. Pursuant to the transaction, Road Motors retained $1 million in cash to pay whatever liabilities remained after the transaction. Finally, also pursuant to the transaction, Road Motors' board issued an in-kind dividend to the company's shareholders, consisting of all the shares of Megabeast stock, and then recommended that they vote to dissolve Road Motors. The shareholders voted, and Road Motors was dissolved. Okay, so first question. C. Strictly as a matter of the rules provided in statutory corporate law, does Biff have a basis of recovery in tort against Megabeast? And the answer is no. Even in the Model Act, in a Model Act jurisdiction, the answer would be no. Liabilities of the acquired company don't follow it to the acquiring company except in cases of true merger. So if it was a share exchange or a purchase of assets or anything like that, there's no transfer of liabilities. They remain the assets, the liabilities of the original firm, whether it becomes a subsidiary of the acquiring firm, as in the case of a share exchange, or merely a freestanding entity with no operating business anymore, as is in the case of a purchase of assets. That may be different if the de facto merger doctrine is applied, but question C asks us to answer the question strictly as a matter of statutory corporate law. Question D. Regardless of how the transaction will be treated as a matter of statutory corporate law, can Biff still recover against Megabeast? And the answer there begins with the observation that this is a Delaware corporation, so de facto merger doctrine is not followed, and the odds seem very unlikely. It's possible that a court in Delaware might draw a distinction between the Haraton case and this case because Biff is not exactly like a voluntary participant in this arrangement. He's an involuntary creditor, as we might say, because he's the victim of a tort committed by the firm that was acquired in this transaction. So who knows, maybe that will be more persuasive to a Delaware court than were the facts in Haraton. But the odds are that won't persuade, given the explanation of the Supreme Court in Haraton and the tradition of the Delaware courts. Moreover, it may be relevant that in setting up this transaction, the parties arranged for Road Motors, the selling entity, to retain some assets to cover lingering liabilities. So that cuts against the equity of recognizing de facto merger. All right, and finally, question E. Despite the risk of taking on Road Motors' pre-transaction liabilities, is there any reason that Megabeast might have proposed to structure the transaction formally as a merger instead? So the question is there any reason they might have chosen to just go ahead and do a merger and take the risk of the liabilities? And the only solid answer really would be tax reasons. Again, mergers are essentially tax-free. They don't have tax consequences for the shareholders of the selling firm. Okay, so after all that, it turns out there's one more thing we have to talk about. We have made reference several times to the so-called appraisal remedy, but not really talked about it. We know what it is in a general sense. It's a right to have your shares reappraised by a court if you think the consideration you got in a change of control transaction was inadequate. Okay, well, there's a couple of statutory provisions that are relevant With my apologies, when I first made up the syllabus long ago, I left one of these off. I only assigned you to read section 13.02 of the Model Act in today's reading assignment. I've corrected that in the online assignment that now appears on Blackboard. And as it says, you should also read section 13.40 of the Model Act, and we'll take a look at both of those now. Okay, so a first and very important aspect of these rules is that under section 13.02a, we get some rules on who's entitled to appraisal. And in keeping with the theme that the Model Act drafters tried to avoid funny business in which people misuse the forms of transactions to avoid shareholder rights, 13.02a gives a right to appraisal to shareholders in all three kinds of change in control transactions. So under subsection 1, you're entitled to appraisal as a shareholder. Generally speaking, when your firm is the target of a merger. Under subsection 2, you're entitled to appraisal where your class of shares was the target of a share exchange. And then finally, under subsection 3, if you're a shareholder in the selling firm in a sale of assets, you are generally entitled to appraisal rights. Okay, but let's bear in mind, though, that each one of these subparagraphs includes some important exceptions. So first of all, in mergers under subparagraph 1, you're only entitled to appraisal rights if you were entitled to vote on the merger. So if you were a shareholder in the surviving firm, then under section 11.04H, you were not entitled to vote, and therefore you're not entitled to appraisal remedies. You are entitled to appraisal remedies, though, under subparagraph 1, if you are a minority shareholder in a short form merger. So even though you were denied voting rights under section 11.05, you're entitled to appraisal. Under subsection 2, we're told that shareholders in a share exchange are entitled to appraisal unless they were shareholders in the acquiring firm. That only makes sense. Then finally, under subparagraph 3, shareholders in the selling firm in a sale of all assets who would be entitled to voting under section 12.02, they're entitled to appraisal, except that there's sort of a complicated little special carve-out for them. The subsection says that if the firm would be dissolved and distribute the assets that it received as consideration for sale of its property within a year, then the shareholders are not entitled to appraisal. That's actually a fairly common sort of transaction, and as we've seen, it's often done in lieu of what otherwise would be structured as a merger. So 13.02b then actually contains some exceptions, even when a shareholder would otherwise be entitled to appraisal under 1302a. There are some cases in which the appraisal right is taken back. The most important is in subsection b, 1i, and that is where the shareholders' shares are traded on a national securities market. The reason for that, obviously enough, is that the courts, or rather the drafters of the Model Act, thought that national securities markets are good enough at valuing shares that at the time of the change of control transaction, there should have been a quoted daily trading price that's at least as accurate as a judgment that a court might make. Okay, there is then an exception to the market exception, and that's subparagraph B3, which says basically that even if the shareholders' shares are traded on a national securities exchange, they will still be entitled to appraisal rights if they were forced to accept any consideration except for cash or very liquid securities. Finally, subparagraph 4 says appraisal rights are in fact available regardless where the shareholders' shares were traded if the transaction was an interested transaction. That means the buyer had a conflict of interest because it also owed fiduciary duties to the target corporation, and that will be most obviously the case where a parent corporation acquires its own subsidiary. Okay, so the section that I initially failed to ask you to read when I first distributed the syllabus, but that I've included now in the online syllabus on Blackboard, is section 13.40. The effect of this thing is to say that where appraisal rights are available, they're usually the exclusive remedy. So that means if a transaction's been consummated and appraisal rights are available. A shareholder can't seek to enjoin the transaction or sue anybody for breach of fiduciary duties or anything like that. The only thing they can do is seek appraisal of the value of their shares. Okay, so that's the effect of subsection A. But again, there's a big carve out from subsection A. It turns out that appraisal is not exclusive in a short list of circumstances. First of all, under subsection 1, if the merger was approved in some procedurally inappropriate way, it violated the rules of chapters 9, 10, 11, or 12, then appraisal is not exclusive. If there was a violation of the articles or bylaws or of a resolution of the board of directors authorizing corporate action, then appraisal is not exclusive. So in other words, if there are procedural problems, not exclusive. Subparagraph 2, if the thing was procured by fraud, appraisal not exclusive. You can challenge the fraud. Subsection 3, if it's an interested transaction, generally speaking, appraisal is not exclusive. So if somebody involved had a conflict of interest. And then finally, subsection 4 isn't really very important for us. Okay, so that is the appraisal remedy. And that'll wrap her up for one more time, friends. See you next time.